Hi, everyone. Happy Wednesday. Hope everyone's safe and having a great day. I'm Lee Leopard. I'm the Senior Creative Manager at the Cromeans Law Firm, and we'll start our presentation momentarily with Kelly Staney, our Associate Attorney here at the Cromeans Law Firm. I just ask that your microphones remain muted while we go through the presentation. And we will have a Q&A after Kelly presents, and I'll open up for questions. You could submit all questions via chat. You can also unmute yourself and ask questions directly to Kelly. Just ask that, make sure that questions are short and concise, and we're so thankful that you all are here and joining us today. I also emailed a handout to everyone earlier this morning, so you're welcome to follow along with that as well. And I'll go ahead and start introducing Kelly. Thanks so much for leading our discussion today, and I'll let you take it from here.
Sure. Well, welcome everyone. Thanks for being so flexible. I know we used to do these in person at our office. Now we're kind of online. Just to let you know, today we are talking about safety terms. And this presentation was planned and, kind of laid out long before everything hit with coronavirus. So I understand y'all may have some questions, in the practical day-to-day as Texas starts opening back up, but restrictions still exist. So if you have any of those questions, still feel free to ask them, maybe towards the end of this, because you may have them, and I want to be able to answer all the questions that you do have. So if you've participated in any of ours that have been going on in the last couple of months, you'll notice that we're kind of attacking certain portions of a subcontract or contracts that generally exist on a construction project. So today is safety terms. And so there are some common safety terms that exist in construction contracts. So that's where we're going to start. And so kind of a background, you'll see here that 20% of worker fatalities were in the construction industry as found by OSHA. It's 1 in 5. And, that's a lot when you think about there's the trucking and the shipping industry, there's the oil field, there's energy, there's a lot of other, labor intensive fields that could be out there taking a percentage of these worker fatalities, but 1 in 5 rests in the construction industry. Another thing that is important is, depending on what your contract says, liability can get shifted up and down the chain. And typically what you see is it goes down. The people with the higher bargaining power, who don't necessarily need you, you need them, will typically try to shift liability to you because they know that you need the work. So you'll agree to a scope of work and a contract price, and then you sign the contract. And so there could be terms in that contract that could affect liability falling on you that your natural instinct wouldn't think is going to be on you or rest on your shoulders. And so one of the things is time is of the essence clauses. You see it all the time. They're always there. For anyone familiar with construction projects, you know that there's delay damages, rain days, things like this where things got shut down and you just can't prepare for them. But typically as a project tracks, you want to get from beginning to end as quickly as possible. What we want to make sure is that safety does not suffer on a time is of the essence clause. And the reason for that is the repercussions of it can be so big. You could be paying us attorneys' fees, you could be paying the other side attorneys' fees, paying for damages. Quite a variety of things can just tack on this list of money, plus just the fact that you have to deal with litigation. And sometimes a little bit of work on the front end will prevent these things down the line. So if you are further down the chain of command, let's say on a construction project, you are a subcontractor or you are a supplier. Typically, you do not see the prime contract, or if you do see it, maybe you don't read it. You're not a party to it. It's typically between the owner and the original contractor. And then that original contractor, as you know, starts finding other subcontractors to do the work. The prime contract is very important. So the number one takeaway that I want you to take from this slide is get your prime contract read the prime contract. They should give it to you. This is because oftentimes the original contractor either passes down responsibilities to you from that contract and just references it. Just says all of the original contractor's liabilities in the prime contract are passed down. Well, that's a great sentence, but you can't know what those responsibilities truly are unless you read the prime contract. Or very typically, one of the first sentences you'll see in your subcontract is, this contract assumes or subsumes all of the prime contract. Well, that's great, but what does that mean? And so you need to make sure when you start a project that you get both of them to fully understand what your scope of liability may or may not be. And the next is, once you read them, the best thing is to go above and beyond safety wise than you're required to do. You know, that's the greatest defense to when something happens, especially when the most common thing that we see is negligence. Everyone's heard that word. And basically it just means that you kind of had like a, oh well, attitude to what was going on. Whether that's truly what you intended or not, that the intent doesn't necessarily matter when it comes to how we fight it out legally in the courtroom. So the more you can prove all of the precautions you took, that not only did you meet what's in your contract, but you took it another step, that's going to help show that you're not negligent or did anything on purpose in these types of situations. So the next thing that you would want to do is build worker safety into your contract and your practice. A lot of times, you know, like I said at the beginning, you just look at the scope, you look at the price, you make sure you can do the work, you're happy with how much you're getting paid, and you sign. And the reason that I would suggest having us maybe help you negotiate extra safety terms into your contract is because what subcontractor is going to really be able to put up an argument against you trying to be safe? Can you imagine someone coming back at you and looking at you and saying, no, I don't want the workers to be safe? So it's kind of an easy protection to get. It's much easier than negotiating a price on a contract. And so that could just be an easy safety net that we can put in, or we can show you what additional terms you may need in your contract to help protect you. So if possible, like this first bullet point says here, require your workers to participate in safety programs organized by anyone on the project site. I don't care who it is. Encourage them to go, require them to go. Have them sign an attendance sheet, whatever it may be to show proof that they were there, again, only helps prove that you took the steps necessary to protect yourself. You can also try to arrange a meeting with the prime general contractor or anyone up the chain from you. Or even let's say you're doing one scope of work, but you're working right next to a contractor that's doing a different scope of work. And let's say y'all are kind of crossing paths, maybe the two of you get together and educate each other's employees of what's going on and what safety measures need to be. Open communication is absolutely going to be your best option on these projects from the beginning. Even if you don't necessarily do something that you think, well, I like carpet, or I'm doing tile, or I'm, doing something that doesn't really carry a big risk of liability, what if someone around you does? And just because you think, I don't do this so I can't get sued, people file lawsuits all the time. And the more evidence that we have that you did what you were supposed to do, or that it wasn't you who were engaging in negligent conduct or hazardous things without following proper protocol, the easier we get the lawsuit to go away or settled or whatever it may be. So, if any of you are very familiar with doing work with the Cromines Law Firm, we like to prevent issues before they arise. And we also want to keep your business running, which means you don't need to be paying us a ton of money to fight off situations. So a lot of these are things we want to help you build into your contracts, to your daily protocols, to keep you from having to call us in certain situations. It's never going to be zero. There's always going to be problems. However, when we can help protect your business, that's the step we're going to take. So that's why you see some of these suggestions here on this slide. And so, again, actively participate and adhere to the safety programs that others put on site, no matter what they may be. Again, put in your own safety programs, even if it's something that's done. Let's say you have an individual who is an independent contractor, they don't always work with you. You know, they work here, they work there, or you're hiring a whole bunch of new people. Have it part of the onboarding, a safety program, you know, that they acknowledge that they attended, that they did all of these things, and just utilize a way to communicate with them so that they know what the safety procedures are. Whether it's once a month on a project, every other week on a project, the superintendent gathers your employees together, or, you know, whoever your contact is on site, just run through some safety things. You know, the more you can do and the more you can write down on paper that occurred and who was there, the better off you're going to be. And coordinate your specific activities with the prime or general contractor. That's going to keep not only you safe, but everybody else. Because not only are you worried about keeping your employees safe, if you're doing electrical work, let's say, and there's certain procedures that need to be followed, but another employee from a different contractor who may or may not even supposed to be on the job that day comes across something that injures them, or they fall from scaffolding, or whatever the issue may be, if you haven't made everyone aware of the situation, that liability could fall back on you. You could be kind of approached in from many different sides with liability. And so we're trying to do the best we can to help you see how to protect almost in a 360 situation, instead of just protecting your own employees, if that makes sense. So another thing for you to be aware of is, in Texas, we have something called the freedom of contract. Basically, you can agree to almost anything you want. There are very few situations where it's illegal to agree to certain things. You know, to keep in mind, we have certain pay practices in Texas, right? A minimum wage, overtime requirements, you know, things like that. You can't agree by contract to pay someone differently. You can't do it. A person cannot waive their right to overtime. The person cannot agree, oh, just pay me $100 a day, that's fine. That's one example of something that would be illegal to agree to in a contract. However, most everything else is fair game. The list of what you can agree to is so long compared to the few things you cannot agree to. Now, in the safety aspect of a subcontract, again, you could push liability around. You can make someone in charge of safety programs, someone not in charge of other certain safety aspects. However, there is a realm that, or a world of OSHA. And what OSHA does is they set certain regulations that you cannot change. So for example, if a ladder is so many feet tall, you have to provide the person climbing it with a harness. Or we all know in certain situations you have to wear certain shoes, or you have to wear a hard hat. You know, these things are just stuff you can't touch, you can't change. They are part of the contract. And so what I want y'all to be aware of is not only that you may have extra liabilities put on you by OSHA, but also what a general contractor, someone up the chain, may be requiring you to do or not to do, may be outside OSHA as well. So you want to be familiar with OSHA, and OSHA is great. They have, you go on their website, have what's called opinion letters. And someone has written into OSHA and given an example of a situation, and someone from OSHA essentially writes this memo or letter back, and it's posted for public viewing that addresses the question. And that's a great starting point. It's not going to answer all of your questions, and depending on the date of when it was released, things may have changed. They don't necessarily take down, you know, old law or stuff like that, but it's a great stepping stone for you to kind of try to get some questions answered. They are a great resource. And when I talked about earlier that negligence is the big thing that we see in these situations if someone gets hurt on a construction project, showing that you made the effort to research OSHA and make sure you are in compliance is another step to show that you aren't being negligent in the situation. So for example, OSHA on their own website, I just took this from one of their things on the website. A prime contractor and the subcontractor can make an express agreement or write it down in their contract that the subcontractor is providing first aid and toilet facilities, right? So that could be something that you agree to under freedom of contract that you as a subcontractor have to do. Make sure you have so many first aid kits, make sure the toilet facilities are there, you get to pay for it and all that kind of stuff. And now the prime contractor doesn't have to worry about it. However, the prime contractor still has to, make sure that he's not incurring liability that's going to cause someone to use a first aid kit, right? It doesn't completely absolve the prime contractor from doing their job to make sure that everyone has toilet facilities or has a first aid kit or doesn't need the first aid kit or things like that. They're still in charge of making sure everything is running under OSHA guidelines. So that's a simple one, just the first aid or toilet facilities. But it kind of shows you that not only could an injury happen, but let's say you were supposed to have a first aid kit. Someone that you never saw on the project that is in a, let's say, completely different side of the project site gets injured and they have extra injuries or an infection or whatever occurs because there was not a first aid kit on site, who's in trouble now? It would be the person that had to put in the first aid kit. And so if you're not aware of even small things like that, that seems so insignificant. In the event something happens, you could be held responsible. So again, favorite term is read your contract. Read it in its entirety. You never know what may be in there. So the prime contractor or the subcontractor are required to comply with the safety terms present in the contract. Pretty simple, but you gotta know what's in there. So read, read, read. If you don't wanna read, send it to us. We're more than happy to go through it and interpret what's in your contract. We do offer I believe it's a flat fee, kind of talking off the top of my head right now, so you can call us and we can let you know, but we do offer contract review. We have an attorney here that is very familiar with subcontracts, and sometimes that's great to just kind of be alerted of what may be there or what you may want in your contract. So again, as I said at the beginning, your contract probably incorporates the prime contract or the original contract. Get a copy of it. You could be bound to stuff in there and you don't even know it exists. And as unfair as that sounds, it's your responsibility to get the prime contract and review it. So make sure you get a copy of it. So if a subcontractor of any tier, anywhere up or down the chain, if you agree to perform any part of the prime contract, let's say, and this essentially means if you're agreeing to perform any part of the scope of building, a building or a facility or whatever it may be, you're also assuming responsibilities to make sure that any OSHA regulations that govern electrical or plumbing or HVAC or whatever it may be, not only are you agreeing to the safety terms written down, but you're also agreeing to OSHA's regulations that cover that scope. So make sure that you are aware of both those legal requirements. So with regard to your subcontracted work, you and the prime contractor can be deemed to have joint responsibility unless the contract states otherwise. So if the contract states both the general contractor and the subcontractor should have the first aid kits, and you think, oh, the general contractor's got it, I'm sure they've done it, or they've told me they've done it, and you don't follow through and just make sure in some way or take some sort of steps to make sure that you have determined if those, first aid kits are there, you could still be held responsible for it. So you want to just be careful about those sorts of things. I know that you take people at their word and, well, they told me. I understand. But again, as we've talked about, taking that extra step only helps you and only takes a few minutes, right? Have someone that you trust, an employee that's on the project, just double check something like that for you. And that's what, again, keeps you safe in case something that happens. Okay, this one is a big one. The relationship between safety terms and indemnification clauses in your contract. Not a lot of people know or recognize that these things exist in their subcontracts. So I'm sure a lot of you are familiar with workers' compensation. If your employee gets hurt, whether it's on the project site, whether it's in your corporate office, for example, whether an employee at Walmart slips and falls, it has nothing to do with the construction industry. It's a way for the worker to have their medical expenses paid, their time off paid to an extent. They fill out a form, it goes through the Texas Workforce Commission, they determine how much they get paid and things like that. Now, your liability for that worker's medical could extend beyond workers' compensation. And here's how it happens. Someone up the chain puts an indemnification clause in your contract that says something to the effect of, if your employee gets hurt and then they sue the general contractor on the premise, the owner of the premise, for damages that exceed the cap set by workers' compensation, you're going to be liable for it. So let's say, for example, you've got an employee, he's fallen from some scaffolding. He gets hurt on the job, let's say really, really hurt, broken his back, mental anguish, the list that just goes on and on and on. And let's say his damages, we're just going to put a round number on it to make math easy, is $500,000, from hospital stays to surgeries to physical therapy afterwards to time off of work. Now maybe his family has lost their main provider, just damages on damages on damages. Let's just say $500,000. They come to you, they fill out the workers' compensation sheet, it goes through the Texas Workforce Commission. They've determined that this employee will be paid $100,000. Okay, great. Now, they work like that because that does not end the step for how the employee can get compensated. That delta, that $400,000 that they didn't get paid, they'll go sue the person who put up the scaffolding or the owner of the premises or whatever reason, or whoever is on the chain, is on the project. They can go sue them and legally they can get their compensation that way. So to prevent that from happening, those people up the chain then put in the contract that if that happens, we're pushing it right back down to you. Seems unfair, and then at that point, what's the point in workers' compensation? And I get it, but they exist and they're legal. I had a case not too long ago. We looked into it, researched it, and those clauses set with specific language that's deemed appropriate by the Texas Supreme Court. They exist, and I, would be willing to bet they exist in multiple contracts that either you have been a part of or that you have had come across your desks. So look for those clauses. Now, hopefully, you never get into a situation where an employee's damages are so high above the threshold of workers' compensation. But what comes with these indemnification clauses is not only you paying those extra damages, but a lot of times it comes with not only your attorney's fees, but almost everyone else's attorney's fees. That's called not only the duty to indemnify, which means pay back medical expenses, but the duty to defend, which means legal expenses. So these can just start, ratcheting up. And again, what happens is these clauses get snuck in there because the people with the higher bargaining power that have the deeper pockets that could pay these types of expenses. They just end up pushing it right back down, which is what we want to protect subcontractors from. So Lee, if you can go to the next slide for me, we're gonna look at some key facts. I know that was a lot of information about indemnification clauses. A lot of it is, it's legal. It's a very legal technicality of shifting responsibility of who pays the cost and damages. And, you know, it's a game of hot potato. No one wants to be stuck with it at the end of the day. We're going to pass it on as much as we can. So you would need to be aware of either A, if that clause exists, and B, if it does, what are some things that we could do that helps protect you if someone got injured? And those protections is everything we talked about at the beginning of the presentation. Attending safety seminars, reading your contract, knowing what you're responsible for. If you're not responsible for putting up scaffolding, have someone who knows what they're doing go to the site and make sure the scaffolding is done correctly. Things like that. So the Texas has a category of things that you cannot use indemnification for. It's called the anti-indemnity statute. The one exception is the one we're talking about here. That does not apply to a claim of bodily injury or death of an employee, its agent, or its subcontractor on any tier. So these clauses, I agree, are very unfair, but they're legal. So fairness and something that's legal, unfortunately, sometimes are very different things. So this one, if you're not aware that it's there, has high consequences. And there are a lot of legal avenues that we can take in certain situations that basically can relieve the liability from you. For example, let's take the example I just said. This employee has gotten hurt and their medical bills may have reached $500,000. You come to me and I see this indemnification clause in the contract. What we may do on the front end is see if there's a way that we can settle for a certain amount of money, maybe above what workers' compensation has given them. And in return, we get a complete release of anything from the employee against any party. So then what would happen then is that prevents that employee from ever filing the lawsuit, from that owner ever realizing there's indemnification, and from ever pushing all of the liability back to you. Now, you don't want to have to pay that if you don't have to, but maybe paying $100,000 extra is going to save your business instead of paying $400,000 extra plus attorney's fees on top of that. So sometimes there's a little bit of a risk analysis that has to go into effect to make sure not only is your employee protected, but your company is protected. And other employees pay attention to how you treat employees in situations. They all talk. And so, you know, sometimes even your public relations, how you looked from the outside of how you handle decisions is going to matter with safety terms. And if a company sees how safe you make not only your employees, but the project site, that only increases your value to get hired on more and more projects. So I know that was fairly quick. Y'all, that was about 30 minutes. So thank you for coming. I know that this is a crazy time, so I really appreciate you taking time out of your day to sit here as I probably talk super fast at you guys. So if any questions, feel free to ask them now. There's a chat function, you can type it there, or you should be able to unmute yourself and ask a question. So if anyone's got any questions, feel free.
Thank you, Kelly.
I have a question.
Sure.
So I work for a staffing company, and we often get last minute calls for just final pushes for finishing up a project. And sometimes we don't even have a work order. We just have a relationship with a construction company or a subcontractor.
Sure.
And they'll just say, we need 50 guys to just finish up this project. You know,
Mm-hmm.
they're only going to be needed for a few days. And, you know, we'll get some general requests for what they need and what the situation is. And, you know, we'll send them there.
Mm-hmm.
And, I guess this is just kind of frightening hearing everything you have to say, because, you know, I don't think I've ever seen a prime contract.
Mm-hmm.
I've heard that before. And I mean, if we were going to staff up a company for, you know, well ahead of time, and we're going to do it for a long period of time, then yeah, we would get the prime contract. But for something that is kind of emergent, last minute, and maybe brief in nature, like we're not really, I don't know if this even makes sense, we're not formally a part of the
Right.
prime GC subcontracting team. We are just kind of called in almost as like a brief service, like we're not a part of the crew. Does that exempt us from stuff, or are we held to all the same standards as all the other subs?
Yeah, that's a great question. So usually the contract governs everything, and that doesn't just mean the prime contract, it means the contract you have with whatever the subcontractor is, and it doesn't necessarily have to be written. So like you're saying, when you have those relationships with a subcontractor and, you know, it's been multiple projects, you know, multiple years, it spans a lot of time, that contract is really just the quick terms you agree to of the employees, this much money, this time. So there's nothing really that's going to extend beyond that. And then as a staffing company, you're further removed from the prime contract, because the only way the prime contract is going to affect you is if a contract that you have with someone, whether it's the subcontractor or anyone else in the chain, says we're incorporating the prime contract. So there has to be some language that pulls this prime contract down to your relationship with whoever you have the relationship with. Absent that, there's no magical way to pull it down to affect you. So if you have a long-term client and y'all have maybe a signed agreement and it's in there, then sure, it's gonna come down, you're gonna want it. But if you have a contract with someone and the word prime contract, original contract is nowhere in there, then it's not gonna come down to affect you. So you do have that level of protection. Now I will say, just because I'm an attorney and we like to make sure everybody's covered, as a staffing company, you know, just keeping good records. I've got someone that's got their, you know, whatever license, whatever type of work that you're contracting with on a construction price or project, excuse me, they have a license, or they've attended a general safety seminar, or, you know, if there's anything like that, I of course recommend you do that for the employees. It depends on how many different industries you're trying to juggle for what you staff. If you're solely a construction project staffing company, it's probably a lot easier to put in that kind of stuff. You know, and so it kind of depends on how your staffing company is set up, but generally you're not going to be liable for things up the chain unless it start incorporating down and down. So even if it got incorporated down to the subcontractor you're dealing with, as long as they didn't incorporate it over to you, then you're going to be absolved of that, and they will take responsibility for those employees or independent contractors' actions in those situations. Now, my background is employment law. I did that for 3 years, and there will be some things that the staffing company may have joint responsibility for, but that generally extends to, are they getting paid the right amount, and other employment issues that don't necessarily have to do with safety, if that makes sense. So it's not like you have zero liability, but it's probably not going to be these types of safety terms.
Okay, thank you.
You're welcome. So if anyone has any questions, free room to ask them. If, what happens to me all the time is I think of a question later in the afternoon or the next day. Here at the Chromians Law Firm, we do offer a free hour consultation. Those generally cover things that are more general, because until we're retained, we don't necessarily really dig into the documents and give very specific legal opinions. But call us with questions. We can help guide you and your business. So if you don't have a question now, don't fret. Just give us a call, send us an email. On my handout, you can see my email information, and I'm more than happy to, set up a call with you at a time convenient, or a video call, whatever you'd like, to answer additional questions.
Thank you so much, Kelly.
I have one more. I mean, if
Sure.
people, are there any particular safety courses that you recommend workers and employees taking? I've heard of like HAZWOPER, 40-hour OSHA training. The Houston Area Safety Council provides that either free or very low cost. I guess just in general, like, is that, what do you guys recommend to, because I'm showing an effort, showing like that you're trying to fulfill the spirit of the law preemptively before.
Right. And you don't want it to be just, Joe or Sam's got this free thing in their garage that they give. You want it to be something, that's legitimate. I'm not, other than things that you just mentioned, I'm not having any pop into my head. But things done by certified entities, whether it is a federal or state level entity, is the best option. So things run by OSHA, email sent to OSHA, or, things like that. Just keeping track of contact made to those types of entities is what's going to absolve a lot of questions about whether you've done your due diligence. And I understand price can be an issue. So just because it's free doesn't mean it's bad. And just because it's expensive doesn't mean it's good. So just doing some research, and if you have any questions, I know our managing partner has been doing this for so long that, if you wanted to send one in and be like, hey, is this legit? We could probably figure that out pretty quick.
I have another question.
That's fine.
So we sometimes get requested to provide workers, and they specifically say they cannot be 1099 workers. They have to be W. Now, contractors and subcontractors will tell us this requirement is because for insurance purposes. And I believe them, but I think that there may also be other reasons for it. And it may be liability swapping.
Yeah.
I don't know if you could elaborate on that.
Yeah, there could be a variety of reasons behind why they want a W-2 worker. I mean, it can be anywhere from making sure that they're citizens of the US or have the right to work in the US. And it could also be because if you treat someone as a W-2 worker, as an employee, and pay them pursuant to how you would take taxes out on a W-2, that even if they're an independent contractor, it's fine. There's going to be no liability that way. But if something happens and you started paying someone as a 1099, and that person realizes, oh, I was an employee, I should have been paid minimum wage and overtime, and then a class action starts, and then there's this big headache. I mean, that could be a reason too. And people don't like that answer when I say, if you're confused if someone's an independent contractor, pay them like an employee, make sure because that covers you, right? So it could be that, could be insurance, it could be a requirement from their prime contract or any contracts up the chain. There's no real one answer, or one size fits all kind of answer for why they may be requiring that. It's also not illegal for them to require that. They can ask for it however they want. So
we've had a weird situation where so many companies have had to furlough or suspend projects, and they want to hold on to their workers.
Mm-hmm.
So they've actually been contacting us to see if we could payroll.
Right.
They're like de-converting their employees to 1099 workers, and then because they're not if they had a salary, they've gone down to hourly, and then the hourly rates are also so low that they're not considered full-time, and so they don't want to have the liability of having them as a worker, but they still want to employ them and provide a lifeline, to get through the next few weeks and months.
Sure.
And rehire them as a full-time employee, hopefully when all this gets resolved. But sometimes when we get these requests, they'll specifically say, we need you to, take on our worker, but we need you to take on our worker as a W-2 employee, not as a 1099. It's like, well, you could have done it directly. You could have just done it.
Sure.
I understand the convenience of us doing it, but then I don't understand the additional request for us to take on their worker as our W-2 employee as opposed to our 1099 worker, which is our standard practice, just because.
Right. That I would want to look at kind of a case by case basis of what's going on, for multiple reasons, because again, it could just be, hey, it's easier to keep them as a W-2. But the other thing is I had a case where it had to do with delivery drivers, but there were so many people involved that my client was technically just the staffing agency. They hired them, they paid them through ADP, did their payroll, but then they got shipped to a different company that did logistics. And then that logistics company did the logistics for DHL and the delivery for DHL. So you've got DHL who doesn't want the responsibility of employment. Then you've got the logistics company that doesn't want the responsibility. So it's kicked down to the staffing company, right? Turns out staffing company, logistics company were considered joint employers of the person. So even though the staffing or the logistics company never spent a dime on them and it got transferred over to the staffing company, we were able to share the liability with the logistics company. So it could be making them feel better to shift it over to you, but for you as a staffing company to know that's not pulling any of their liability if something were to happen during this time, if you're not paying them correctly or anything like that. Joint employer is something that can surprise a lot of people in these situations with regard to how you pay the employee under the FLSA. And so they may be thinking that's what they're doing, but in reality, that's just kind of like a legal thing that they're not quite protecting themselves from. And it also depends on if there's someone that you have a contract with. Is there a contract that governs, situations like this? Our answer usually is no, because no one's ever seen a situation like this before.
Right.
But that could be a requirement there. And then again, the next consideration is, who am I working with? Do I trust this company? Do we have a good relationship? Do I not want to burn bridges? That's all going to be a case by case basis of what's really going on and things like that. But I can't see, if they're not working and they're just trying to get kind of a payroll out there, I can't see there ever being true liability for how someone's getting paid during this time, because you're not really on the clock. So I'm not really busting any sort of minimum wage requirement.
Right. No, I think I have like a list of 7 or 8 issues that we need to talk about with y'all, and it's just a matter of setting up a time to like come over and pay you guys the retainer and talk about.
Yeah, sure.
Because it's not just one thing; it's this and like a few other things.
Yeah, so that's the great thing too about our general retainer is it covers anywhere from contract review down to making sure you have a proper employee handbook. We try to be kind of like that one-stop shop. So right now, it is a little difficult as far as coming in just because of us trying to also follow the COVID regulations.
Yeah.
But when we get done here, just shoot me an email. and we'll see what we can work out as far as what we kind of need from you and what you need from us, and we can get started.
Cool. Thank you.
All right. You're welcome. Well, it was a pleasure talking to you. So have a good one.
Thank you, Nicholas. Appreciate it.
All right. Thank you.
Bye-bye. Thank you.
Bye-bye.
Thanks, everyone.